Welcome and thank you for joining us this morning, April 2nd, and let's dive in. So I would love to introduce myself to the group here this morning, and then I'll ask if there's anything that you want to share about yourself. I will then cover some of the basics about what would happen to your stuff when you die if you don't have any plan in place. So that means covering what the state's plan is. I'm also going to touch on probate and when that would come into play. So if you do already have a plan in place, maybe a will, maybe you even have a trust, I'll give you some idea of what would happen under that plan. And then we'll talk about some different planning tools available to you. And I'll cover what would happen if you become incapacitated, if you could not make your own financial or healthcare decisions for yourself, what you can do about that, and what the consequences are if you don't put a plan in place. I'll cover some free tools available to you, and then give my opinion on when you should talk to a lawyer, and then open it up for questions. So like I said earlier before recording, I will probably talk for about 45 minutes and then open it up for your questions. So my name is Liz Smith and I live in Juneau. Liz Smith Law serves people all over the state, but I came to Juneau with my now husband in 2005. I left a couple of years later. I wanted to go back to school, and with my economics degree and not being so good at math, I ended up at law school. I ended up loving law school. I was in Vermont, and a really great school for me. And I just ended up loving it. I thought I was going to hate it, and that didn't happen. I also thought I was not actually going to practice law. I thought it would be a good background for whatever I decided to do with my career. But I loved law school so much that I started thinking first about environmental law, and then somehow got hooked on wanting to be a public defender. So representing individuals charged with a crime who cannot afford an attorney. I interned at the public defender's office during law school. So during summers in the 3 years of law school, the internships are a really important aspect of that. I wasn't hired right away. I took a couple of different jobs out of law school starting in 2010, and then was a law clerk for Judge Pallenberg, who recently retired here at the Superior Court in Juneau. And during that year, budget cuts were starting in the state. I know we've had a few rough spots with the state since then as well. But during that 2012 year, when the public defender's office is hiring, I was the only person hired that year because they were limiting their numbers, but that position was up in Barrow, or Ukqiagvik now, as it's called. So I went up there happily for 13 months, and it was a great experience for me career-wise. I was the only public defender, and really amazing, like I said, career-wise. But my husband and our dog at the time, who was the yellow lab up there on the upper right-hand corner of your screen, and my husband is down below with me here. They stayed in Juneau, and I was eager to come back when I could for family reasons. So I came back to Juneau, I guess that would have been 2013, and worked at the public defender's office here. And that was great for a while, but I was mostly representing parents when the state takes custody of their children, and that was not a good fit for me personally. It was great for a while, but I burned out pretty quickly. And I went over to the Department of Law, where I worked for about 4.5 years, representing part of Department of Health and Social Services. And while that was okay, I had, first of all, a dream of starting my own business since very early on. So along the way, I kept thinking if I don't get a certain job, I'll start a business, and kept getting the jobs. And that felt like the right thing to do. Working for the state has its perks. But I started a health coaching business in 2017 on the side, and I really liked helping individuals on their health goals, but I also discovered that I liked the creative energy that came with running the business and doing blog posts and educating the community. I was really enjoying it. And I also hit a point where part of the legal profession, usually attorneys are representing individuals in conflict, right? No one wants to go see an attorney most of the time because it's usually for something bad. And I was tired of being the attorney brought in after conflict was already existing. I wanted to help avoid conflict. So I left the state in 2018, took some time to really figure out what was next for me. I thought I actually might leave the legal career altogether. And of course of events happened, worked for a tourism company for a while, and then decided it was time to give it a shot to start a business and maybe use that law degree. I looked into estate planning as a way to meet some of things. I thought it might be a good fit for me. And I found a really excellent training program that's been incredible. So I started Liz Smith Law in 2019. This June will be 3 years, which is kind of crazy to me now. And I haven't looked back. I love it. I love with our Liz Smith Law focuses mostly on estate planning, doing wills and trusts and helping people plan. We of course do post-death administration as well. So after someone dies, what has to happen and guiding people in that. And then we also serve small business owners and assist them. And my goal, like I said, I was a health coach helping people achieve health goals that they were struggling with. And I find a lot of similarity. When I think about our work as a law office, I think about stepping into, attorneys are called counselors at law. And I really want to focus on that part of helping people through a process. And with estate planning, it's the type of thing that is the easiest in the world to put off, right? Like, it's amazing how many clients just think, well, I'm young, nothing's going to happen. And yet they still come and see me often though, because they know someone that did die unexpectedly. But we think that we can put it off forever until potentially it's too late. And even when you get started, they're hard topics to discuss, right? What's gonna happen if you have young children, not something that's fun to think about of you not being able there to see them. And so we have put systems in place, and I see it as our goal really to help you, if this is something that you want to do, to put a plan in place, help you move through the process. So make it as easy as possible for you to do that and to get a plan in place that's going to meet, protect your loved ones if something does happen to you, protect you if something happens to you and you're incapacitated, and then just give you the peace of mind knowing that this part is done. If something happens to you, they're going to be protected in the best way possible. You can go about your life, and then of course check in on that plan regularly so that it doesn't go stale. It has to stay up to date with your life. So that's a bit about Liz Smith Law. We are expanding, so it's myself and then another attorney, Kate Higgins, who also sees clients, and we have a wonderful team. Alex is here with us this morning, and we have a few other team members now as well, making sure that things run smoothly for you. I introduced one dog. The little black dog is Sophie, and I got her when I was up in Barrow as I needed a companion since Quinn, my husband, kept the other dog. I do love to travel. We both love to travel and look forward to doing more of that. I also love triathlon. The picture of myself on the bike is doing my first Ironman triathlon in Australia. And you may know Ironman's coming to Juneau. So that's exciting. On the picture on the right, lower right, I wrote a book as a health coach, 30 Weeks to Awesome, 30 weeks of different health goals. And for a while, it was in the fireworks gallery in Seattle. Kind of fun. So, all right, that was too much about me. If there's anything you'd like to share about yourself, either when you put it a note in the chat, you can share with the whole group. The default is going to be everyone, but you can also select someone in the drop down. You can select myself, and even better, Alex Weddle, LSL. That's Alex, our Client Services Director. And throughout the presentation, you're welcome to question her directly. If you have a question you want me to answer at the end, she's probably the best to help tag that, or you can do something to the whole group. And if you have questions about our office or want follow-up, message her as well. All right, while you're doing that, I want to make clear that while I am an attorney licensed in Alaska, I am not your attorney unless we have a written attorney and client engagement agreement. And so the information I'm sharing today is not specific to your situation. You may have something that would change what I'm talking about. Everyone has their own unique situation. This is just meant to be general. I will share with you how to get information more specifically to your situation. All right. Why are you here this morning? Did you come to get the total assurance and comfort knowing your family would be taken care of in the way you want if something happened to you? Did you come for the peace of mind knowing what would happen to your assets at your death? Or maybe you came to find out how to make sure your family does not pay estate taxes unnecessarily. Maybe you came to make sure that you'd be taken care of in the best way possible and that the best decisions would be made for you if you became incapacitated. All these are great reasons to be here this morning. You'll learn what you need to do to have the peace of mind knowing that you've made the right decisions for your family during your lifetime so that at your death, things are as easy as possible for the people you love the most. So let's dive in and start talking about what the state's plan is for you. So that means what would happen if you didn't have a plan at all, the default plan. For most people, the default plan is going to involve probate. Probate is a lawsuit you file against yourself for your own money for the benefit of creditors. That is a bit tongue in cheek, but only a little bit. It typically takes, probate, backing up, is the process to transfer to change the title on any assets in your name at death to whomever is going to inherit them. It is a lawsuit, and if you don't have a plan in place, there's a statute that indicates who would serve as your personal representative or executor. And if you're married, that's going to be your spouse. If you have adult children, they would all have equal priority. So sometimes that's easy. Someone steps forward, it's clear to everyone who that would be. Other times, if there's multiple children, there's a room for argument, in which case the judge would have to decide who to appoint. Again, this is with no plan at all. So you might consider in your own life who would step up to be personal representative. It's possible they would have to post a bond. And so there's some chance that someone couldn't serve even if they wanted to. That person's role is to meet certain court deadlines and procedures. They need to make sure final taxes are filed. They need to publish notice to creditors. There's a variety of steps that have to be done. And it's a lot of responsibility and a lot of work. And typically that's going to take 12 to 18 months, even if they're moving as fast as they can. It is a public process, so anybody can see to go to the courthouse and look at the file and get a sense of usually of what you have and who's likely to inherit the assets that you have. It can be expensive with a variety of fees. I typically say about 1 to 5% of the value of the assets going through probate. So that's just a very rough estimate, but to give you some idea that it costs money to go through that process. And that cost will come out of the estate before assets are distributed. And then think about who is going to inherit if you don't have a plan in place. If you are married and it's not a blended family, so there are not children from a prior relationship, then the spouse would inherit everything. If there are children or even parents of the person that died, there's some kind of wonky things in statute where it might not be 100% to the surviving spouse. If the person had children and no spouse, then assets would go to the children. So there's different, the statute indicates where assets are going to go. Of course, you can control that if you want something different to happen, but do know that in a blended family, it can be a little bit awkward if you want everything to go to your spouse and then be split amongst the kids. That's not what would happen if there's children from prior relationships. And of course, if you wanted to give anything to charity, that's not written into statute, so you have to take action to do that upon your death. And then if you have minor children under 18, they of course cannot inherit assets outright. And so the court would appoint someone to take care of any assets. They're still for the benefit of the children. And the moment that child turns 18, they would receive everything outright to do with as they want. So there are ways that you can give assets to individuals that are protected or even protected until a later age. But if you don't have a plan in place, then everything just goes outright, or if there's a minor child, then outright at age 18. Now in Alaska, there is a process you can file, or you actually avoid court if certain conditions are met. And all three of these have to be met to avoid probate. Oops. So first, if you do not own any real properties, that's house, land, things like that. And we're talking in Alaska or another state. So no real property. Actually, take that back, on another state. That's more complicated, but we can address that individually. Vehicles you own if they're worth $100,000 or less, and if the entire value of the assets is $50,000 or less. So all three of these conditions must be met to avoid probate. And when we talk about the value of all assets, that's assets that would go through probate. So you may have a lot in life insurance and retirement accounts. If there is an adult beneficiary named on those accounts, they will go directly to the beneficiaries and not through probate. So they would not get counted in the $50,000 or less. If you don't like the sound of probate and don't particularly want your family to be stuck going through that court process, a will does not avoid probate. A fully funded living trust does avoid probate. We're going to come back to some of the advantages of a will and a trust and what a trust is in just a moment. But first, I want to cover estate taxes very briefly. Estate tax or death tax is a federal tax. We don't have a state tax in Alaska. An estate tax in Alaska, and your estate will pay the tax, but only if the estate is over the exemption amount at your death. And that exemption amount, I can't tell you what it's going to be at the time of death. What I can tell you is that today it's over $11 million. I am pretty sure that that's going to come down. It's already, if the legislature does nothing, it'll come back down in 2026. I think it'll come down significantly, but I don't have a crystal ball, but it's still likely to be fairly high. And what the federal government's looking at for purposes of whether you're over the exemption amount is only the equity value in something like a home or a car if you have a loan. And then everything else. So your life insurance and retirement accounts are going to be included, any business assets, any investments, automobiles, etc. So there's easy planning if that is something that you're worried about now or in the future, especially for married couples. There's easy planning, and there's other things to do as well, just to move assets out of your estate if that is something you're worried about. All right, so I covered a bit about what the estate's plan is. Roughly, you can kind of imagine probably in your situation. But what if you have a will, or what if you want a will? What are some of the advantages? A will can help keep your family out of conflict. So with a will, you get to decide who you want to be your personal representative, and you get to decide where assets go. And that can go really far in reducing any conflict. You have control because you're taking control, not dealing with the state's plan. You get to make your own decisions about what's going to happen. It's perfect, of course, if you're not going to face probate anyway based on assets. So you might look at your estate and say, well, I wouldn't have probate, but a will can still be really helpful, and it's just a backup even if you have assets that wouldn't go through probate. Would face probate. A will is important if you have minor children to name who you would like to raise them if something happened to you. All right, so what about a trust? I mentioned that with a living trust, it can help you avoid probate. It does that because a trust is an agreement. There's lots of types of trusts. So if you've heard about trust and you're familiar, or Uncle Joe had a trust and it worked this way, know that there are many, many different types of trusts that can be set up. So I'm talking about a living trust. A revocable living trust is another way to say it. And its main focus is keeping your family out of court. There's other advantages. There's other reasons I really like it, like trust as a tool. But its main objective is to keep assets out of probate upon your death. That means that administration after death can be much quicker if the family wants to move quicker or just whatever pace they want to move. There's more flexibility, and it tends to be much cheaper than going through probate. Something else I was we'll see if so trust owns your assets. I'm trying to think of what I was about to say, but and then distributes per the terms of your trust. Avoid probate. We'll see. All right, so with a trust, you have even more control for a variety of reasons and where assets are going to go. Especially there's ways if you're married that you can protect assets for the surviving spouse in a way that you wouldn't with a will. You can ensure your children do not inherit outright at age 18. There's some ways to do that with a will as well, but it's more streamlined if you use a trust to do that, so they can inherit at 35. You could also leave assets to them in a trust for life. You can, with a trust planning, limit distributions. Excuse me. So I'll share a personal story. So my mother, very early age in high school, got extremely involved with drugs and alcohol and barely finished high school. And then went on, she had me, she had a low-level job and was able to basically support herself. And then her parents died and she was an only child. She inherited everything, which wasn't a huge estate, but it was enough for her to sell the home in California, move to Oregon, and buy a cheap house and a piece of property. And didn't work and got pretty involved just doing drugs and racking up incredible debt at the end of it all. And what her parents could have done had they wanted to in a situation like that, if you have a child who's not great with money or who might, use it in ways that would harm them, you can limit distribution. So you can name someone else to manage the money. It's called a trustee. Name someone else to do that. And you can give that person the power to say, you have to do drug tests, and if you fail, you get no distributions, or you have to have a job. Unless you can't work for some reason, you have to work or you don't get distributions. Anything that you think that you might want to do, you can do. I shouldn't say anything, but you have lots of flexibility with a trust if that's something that you're interested in. I know plenty of family members that don't want any control over the inheritance that their children are going to receive or other members of the family. You get to decide what your comfort level is, but know that you can set restrictions if you wanted to. Another great thing about trust planning is that you can leave assets to your beneficiaries in a way that protects them from their creditors. And there's a variety. So that could be if they get divorced, you're protecting them. And that could be if they're involved in some type of litigation. And there's different ways to set that up. But that's in leaving assets to a trust. So setting up the living trust itself doesn't provide you asset protection, but you can easily provide it for your loved ones after you die in a way that they really can't do it for themselves. It's a nice gift. All right, one thing, if anyone does have minor children, is I mentioned using a will to name who you would want to be guardian. But then what about the short term? So if you and partner or spouse leave your kids with a babysitter and go out to dinner and you're in a car wreck on the way home, it's hard to think about, but realistically, what's likely to happen? You have a young babysitter, he or she calls the police and they come, and they would have little choice in most situations but to put the children in the care, probably into foster care, some kind of foster family for the immediate future if they can't find you, or if they find the parents and know that they're incapacitated and can't communicate. So luckily in Alaska, most of us are in small communities and there's some more flexibility than a big city. But what if you had directions for that babysitter to call close friends, people that know, love, and trust, that you trust and that your kids trust. And the babysitter would be directed to call those individuals. They would come over to the house with legal documentation that that's who you want your kids to be with, or that it's okay for them to be with them. And then that gives the police more leeway, much more leeway to say, okay, this person or this couple, the kids can go with them until we figure out what happened to mom and dad and get things squared away. So we have something put together, we call it a kids protection plan for minor children, and it includes a variety of documents to ensure that your kids would be protected in the very immediate future. Make sure that someone can make decisions, healthcare decisions for them if that were needed, and that they have the authority to be with them until the long-term guardians get appointed if that were to be needed in the situation. We do have a link that Alex just shared. Excuse me. And you can go to that link and do some free documents for minor children on your own. And then you can also talk to us about a kids protection plan. A couple of things just to mention that you might want to think about if you're in a certain situation. Community property is complex, but briefly, if you are married in Alaska, you have the option by default, you own property as separate property that has a legal definition with it that's different than what it might sound like. But you have the option to own property as community property. So that has a ton of consequences if you were to get a divorce. But for estate planning purposes, what I'll tell you is that if you're married, divorce is unlikely, and you have highly appreciated assets, meaning there's been a huge gain and you would owe capital gains if you sell that asset, then you may benefit from choosing to own certain or all property as community property. And what would happen then is if the surviving spouse sells that property later on, they would pay less capital gains tax on the asset. So I'll leave it there, but if that sounds like something, make a note and we can, I'll show you how to get more answers specific to your situation about it. What about long-term care? If you were to need, I think I just saw that nursing homes in Alaska these days are roughly $30,000 a month. So if you need long-term care, even you may run out of assets really, really quickly to pay for that care. So of course there's long-term care insurance that usually doesn't cover a significant period of time. It usually fills in a gap, but there are ways to plan for long-term care costs so that you could protect some assets, but still turn to Medicaid should that be needed to pay for a nursing home stay. So if that's something that you're concerned about and you want to make sure that you protect some assets to go to your children and you have time to plan, that's something you can do. Or if you need long-term care in the immediate future, sometimes there's different planning tools and our office does help with that planning. So what about incapacity? So if something happened to you and you couldn't make your own decisions, so think healthcare, financial decisions, whether that's a short-term type of coma, or if you have dementia sets in and you can no longer make decisions, or just old age and it makes it tougher to make decisions. I have an aunt who's 85 that she's tired. She's at the end of her life and her mind still works okay, but she doesn't have the energy anymore. So I'm taking over for her finances. So in those situations, what happens if you haven't done anything, right? And you're in an accident and someone has to make decisions for you. They have to go to court and get appointed as a conservator or a guardian. That can be expensive if you hire an attorney to help through the process. It definitely takes a long time. Our judges in this state are very, very backed up. And then there's going to be oversight from the court. So whoever is guardian has to file a report every year. And it can be a hard process to go through. If the alternative is naming someone to make those decisions for you while you have the capacity to do so. So that, of course, has the advantage of you deciding who you want to make decisions for you. And You can also direct the type of decisions you would want made. So that's, you can do through power of attorney and then healthcare advanced directives. In Alaska and most states, they have statutory forms that you can find for free and fill out. I recommend that for anyone who's over 18 the moment you turn 18. So we have some links here that Alex is also putting into the chat box. The first is a healthcare advanced directive from Department of Health and Social Services. The second resource is power of attorney. And then we also, I like 5 Wishes. You can look at 5wishes.org and they'll send you, or we have in our office, paper forms that allow a little more. I just like how it's written, and you can indicate how you would want to be cared for in certain situations. I don't love the Alaska Advanced Directive form. I don't think it's the idea is to express what you would want to happen, but it's a bit confusing in the way that it's written. Good things to have in place. Of course, I'll talk about how all of our plans, we include sets of documents to make sure that you're deciding who would make decisions. Now, I also think of our role as really helping you think about not just what happens at death in terms of your assets, but what happens, what kind of legacy do you want to leave, right? And so that's both how do you leave assets and to whom, and talking to them maybe about what's going to happen or what you have, how to steward the assets that you leave. But then also, what about your stories and insights that you've learned over your life? You may have told your children the stories many times, but maybe like me, they weren't listening very well. And so how do you leave some of those stories behind as a gem for them? We incorporate that into our planning by offering legacy interviews as part of any plan we do. And that's a Zoom interview and you can record. We have really great interview questions and it allows you to share some of those stories. If you have minor children, it's a way to share how you'd want them cared for if something happens to you. So that's going to be a nice snapshot that you can then turn to in the future. And hopefully, right? Hopefully you'll live until your children are adults and you can watch that with them and get a laugh out of it. But if something happened to you, you have that to share and pass on. There's lots of other ways to think about leaving that legacy. I gifted Storyworth to family members. That's they send an email every week and you can write just a quick, the idea is to break up writing your life story and you can answer a simple question. And at the end of a year, they put together a book for you. I have a podcast and I did an interview a while back with someone named Nim de Swart. She's in Australia, but is starting a company that's really neat. They're doing some really neat things about sharing stories. And Alex just linked to that if you want to check that out. All right, so what about, what can you do on your own? When might you want to turn to an attorney? I, of course, am biased, but it's not just because this is what, not just to drum up business, but also I see how complex it can be to plan for your death and think through different factors. A lot of what we do is just, well, what if, asking the what if questions and helping you think through things that you haven't thought of before. As with, I have a colleague who was went fishing with his son, and it was very clear that he didn't have things set up right and they weren't working well. And he thought about how he knew he hadn't set up the fishing equipment correctly. But with an estate plan, you don't know what's going to happen until you die. So one thing that lawyers provide, of course, is added assurance that the people you love stay out of court and out of conflict. We also can be someone to turn to when something happens to you. So I offer, actually right after this at 11, I have a family meeting. And we meet with the people that are going to carry out your plan. So I do that. I think other attorneys they should be doing that to give you, to start meeting the people that were carrying out your plan. My my grandfather recently passed, and my aunt had started meeting with her parents' attorney, and that really helped her. So when she was in the midst of grief, she at least had some knowledge of the person and trust built up and who she was working with to administer the trust. Sometimes it's easier to hire someone else to do it if this has been on your to-do list and not gotten done. If you want to create a trust, I have seen some trusts that people have gotten online, or like walk-in trust, even with an attorney, but just a like walk-in place. And they're not going to work. The ones I've seen are not going to work the way that people wanted them to. And once you set up a trust, you have to transfer assets to it. And that is complex. It's not straightforward at all. And it won't work if you haven't done that correctly. So if you want to trust, I would recommend you work with an attorney. If you're in a relationship and not married, there are not the same legal rights as a married couple, I would recommend working with an attorney. If there's children from prior relationships, blended families, there's planning tools that are can be really beneficial that an attorney can tell you about that are harder to navigate on your own, any unique situation. And with all that said, there's some great free resources on the Alaska Court website, a lot about probate, but that kind of gives you an idea of what would happen. And Legal Services has some resources as well that Alex will link to. Excuse me. All right, so with all of that, I'd like you to take a moment and consider what is most important for you that you heard. So you may be put at ease thinking that you're comfortable with what would happen. Or maybe you think, well, I really would like asset protection for my children. What is that? Want to learn more about it? Maybe you want to make sure that you're controlling how and when your children inherit. Or maybe you want to avoid probate, whether that's because of the time it takes or the cost of probate, or to make sure that things are private for you and your family. And then I'd ask you to think about the next step, to take care of whatever it is that's most important to you and keep things moving, right? So because you're showing up here this morning, I know that you either, this is on your to-do list to take care of for yourself, or you're looking for information for somebody else. And you took a first step by coming here, but I invite you to think about the next step and what that would be. So you might be thinking, you know, what if your family ended up in court? What would that look like? And like I said, our goal is to help you move through the process. So by writing that down, committing to that step, whatever it is, and one next step for you may be getting really clear on what's going to happen to you and your family. If more specific to your situation than I've gone through here in the more general. And so what I would recommend is we offer a life and legacy planning session. And that is a 2-hour working session, either virtually, like I said, I'll work with anyone throughout the state of Alaska. And even in Juneau, I'm still doing some virtual meetings, or we have an office downtown, and we sit down and look at what you have. You share family dynamics. I share what under the law, what would happen. And then we look really what would happen to the people you love if something happens to you. And then you decide what about that works for you and what doesn't. And from there, during that meeting together, we would choose an estate plan that would be best for your family from both a cost perspective and from an outcome perspective. So even if you think you're comfortable with what would happen, I'd invite you to take advantage of that life and legacy planning session. Because you are here, normally that meeting as a 2-hour working meeting costs $750, but because you're here getting the basic education and ready to jump right in, I'm happy to offer that to you complimentary. And I mean that. I think education is important as anything. With a catch that the only way to get the meeting for free is we do ask that you fill out an inventory ahead of time. I call it the homework. And that's really important for it to actually be a useful working meeting. And going through the inventory is a helpful step for you, because one of the biggest, I'll say it in a positive way, one of the best things you can do for your family is be organized about what you have, where things are at, who are the beneficiaries, and just going through that process of looking over everything can be really helpful for you to get organized, but also to leave that behind for your loved ones. So if you do the homework, I'm happy to meet with you for free. And then as an additional incentive, if that's your next right step to help you move along through the process, if you schedule an appointment today, then we'll also give you an extra $250 off if you decide that you want to plan with us. So that's fully $1,000 of free legal services. If you want to take advantage of that, you can go to this link, which Alex just shared in the chat box, and you'll see a calendar and you can decide what makes the most sense for you. I think you're not going to be able to schedule in the next couple of weeks anyway, because we're booked up. I usually say schedule at least a couple of weeks out to give you time to complete the homework. But I will say that if now is not the best time, you want to get that appointment on the calendar, it can be many months out if that's the right thing for you. If you are planning with somebody else, we want to see them at that meeting as well. And if they're not here this morning, let us know and we could send them if you want them to watch this, or we would want them to watch this as well. It's helpful. All right. Just to make clear, the Life and Legacy Planning session is anytime you schedule with us, just make sure that you mention you attended a webinar. The $250 is only if you schedule today to help you move forward. All right, so I'm going to open it up for questions in just a moment. If you're wondering if that's your next right step or have some other questions, I'm happy to answer them. Quickly, I want to go through our process so that, well, I know that working with an attorney can be daunting. And so I think it's somewhat helpful for you to know what would be coming. I think it's always good to know what's ahead. And then I'll stop and open it up for questions. So working with us, and remember, it's myself or Kate. I need to add a picture of her. So we would schedule, and then we'll make sure that we have we'll only get to get information about anybody planning, and we need to get your address. So we're going to send you a form. Sorry, we switched up our calendar system, but I don't think there's a place for you to put your address. If there is, then that'd be helpful. We may have it from your registration for the webinar. If we don't, we're going to contact you, send a form out to you and ask for your address as quickly as possible so that then we can send you our pre-meeting packet in the mail to give you some extra background. And then you do your homework, filling out your life and legacy inventory and assessment. You also begin to gather documents before your meeting. So deeds, account statements, if you have divorce or prenuptial agreements, insurance policy declarations. The best thing to do is bring those with you to your meeting or provide them ahead of time. It's not required, but it can be really helpful. Then we meet, get clear on what would happen to the people you love and your assets upon death. You decide if you want a different plan. What does that look like? And then within that 2 hours, if we decide there's a good fit between yourself and our office, then we can go forward and design your plan during that 2-hour meeting, or schedule another design meeting if needed. Usually you're signing documents about 4 weeks later. If you're out of town, that's going to be closer to 5 or 6 weeks. We go through everything, you scan, we keep everything with us, and then meet once again. So we have a 3-meeting process at least. And at the binder delivery, we go through some next steps. You get everything. In between meetings 2 and 3 is your legacy interview. And so I guess that's 4-meeting process. And that's, of course, the opportunity to record your stories. So then at your final meeting, we can provide those to you on a USB is how we do it. And then, so super important is we offer a free review at least every 3 years, more often for our VIP members. We have a membership program for people that want more support, but at least every 3 years, we invite you to come in, look over your plan, see if any updates are needed. And that is as important as taking your initial step, because the law is going to change, your life is going to change, and a stale plan is often worse than whatever the state's plan would be for you. So a stale plan meaning you named people that are deceased to serve in certain roles, or you have some something else going on. All right. We do work with a variety of legal service plans if you work for the state and have ASEA or APEA and some others listed here. And that is it. I talked for a good long while this morning. I hope it was beneficial, and I'd love to answer any questions you have. If you found, we also love your feedback. If you found this valuable and you'd like others to join, I'm doing them at least once a month, if not more often. And you can check out lizsmithlaw.com/events on our website for any updates. And if you're in our newsletter, we post them there as well. So thank you for joining us. And